Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Deifik, attorney with the law group Ross, Lanier, and Deifik.
Thank you, Morgan, for the introduction. Well, thanks for coming back on the show here, and we're continuing from another segment we did, but for the viewers that didn't see our first segment, would you please tell us a little bit about yourself?
Sure. Celia Ellen Deifik, and I practice with Ross, Lanier, and Deifik, PA, law firm downtown. Don Ross and Suzanne Lanier are my partners, and we have an associate and some great staff. I litigate real estate issues and some business issues also, and I've been board certified in real estate since 1990.
And where are you located?
Our office is in the Capital Bank building, and that is across from Pastrami Dan's downtown, corner of 6th Avenue North and 41, about 11 blocks north of Four Corners.
Yep. So we had another show we were doing with you, and we were talking about deposits and the different contracts and everything. So this segment of this show is about if somebody defaults in the contract, where do we go with their deposit? What happens, or how do we put it together?
Well, first of all, you should consult counsel, and they can give you a lot of insight.
Exactly.
I think people make an error when they don't, and certainly talk to your real estate agent because they have a lot of experience. It depends first on which contract you're using, whether it's the NABOR contract commonly used in Collier County, or the FAR-BAR, which is used throughout the state, and more agents are using it in Collier, or is it perhaps a contract with a major corporation, a developer contract? Right. Now, the FAR-BAR contract requires you to go to what's called pre-suit mediation, and that's really a good idea. And so I usually advise clients, first, we try and just talk with the other side. Maybe the other side has counsel. We can split the baby or work something out. But I like to schedule mediation as soon as humanly possible. The day people walk into my office, I like to try and line up some mediation dates that are 10 days, 14 days out. The FAR-BAR contract requires people to try and resolve things for the first 10 days, and if they can't, to go to pre-suit mediation and split that expense. People, I think, are intimidated by that because they're not familiar with the process, but it's really fairly easy to set up, and the mediators are usually attorneys who are themselves very familiar with what happens in the court system, and many disputes are resolved then.
So a mediator typically is a person that's in between both parties, that has no interest in both parties.
Exactly.
And he is an attorney, and what he's trying to do is just try and solve this with both parties.
Exactly.
That maybe both aren't going to be the winner, but we can resolve it before it gets to the courts, right?
Right. And I think people need to be prepared to make business decisions rather than emotional decisions. Now, if it cannot be resolved at mediation, then our only recourse is to file suit. I know a lot of people are resistant to filing suit, but what they don't realize where there's large deposits involved is if they don't, the other party will, or the escrow holder will, because the title agent
holds the money.
Who is holding the money, or the realtor who is holding the money, is not willing, and in some cases by regulation is not permitted, to hold that money for extended periods of time. So they will eventually file what's called an interpleader action, where they ask the court for permission to put the money in the registry of the court, and also ask the court to demand the buyer and seller to file pleadings as to why each should get the deposit, if that's what is at issue. Now, there are more remedies than merely the deposit. So I think it's important for people to get a good feeling about what will happen so that they're not intimidated by the process and they can make some common sense decisions.
When the money is in escrow and it's disputed, and like you said, I'm familiar, it goes to the courts, and both parties have to file a suit. Could one file for the deposit plus damages? Or
Absolutely.
They can, okay.
Absolutely.
So there usually is one party that's damaged more than the other, maybe.
Very frequently. Now what they can also do is they can seek what we call equitable relief. Usually that's specific performance. And that happens where the seller is unwilling, most frequently. There are other instances, but most frequently I would be bringing a specific performance action or defending a specific performance action where the seller got cold feet and no longer wanted to convey the property. And I've been on both sides of that. During the run-up to the Great Recession, when prices were going up, it seemed like by the week, we had a number of instances of sellers who decided, hey, I could get another $100,000 for this. I'm not going to honor that contract. And they would offer the buyer back their deposit. When the buyer came to me, I would say, you're entitled to a great deal more than that. And I think that buyers need to be conscious of the fact that in many instances they are entitled to a good deal more than merely the deposit. The Florida Supreme Court has said that mere return of the deposit in certain defined instances is not sufficient damages.
Well, we're going to take a little short break, and we'll be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. We've gone to court, okay, or we filed lawsuits, okay. Does that mean we can't settle?
You can always settle. You can always settle. And what people should know is that, and this is true even if they've done pre-suit mediation, the judge will almost always require people to either mediate or arbitrate before he takes it to trial. And I've had great success with both. And I've had success at trial also. It really is a matter of how invested I think the client is in their position. Usually suits over real estate contracts are resolved with a little give and take. And what I think is necessary is to be able to really articulate your side of the situation. And when you're representing the buyer, you're in a bit of a better position because so many of the laws, the state laws and the federal law, like the Interstate Land Sales Full Disclosure Act, are designed to favor the buyer, and in fact the courts are instructed to construe them, to interpret them in favor of the consumer. So that's very helpful and sometimes can drive settlement. Further, the Florida legislature and the Florida Supreme Court have built in certain tools to try and press people towards settlement, both sides.
Right, yeah.
So.
Yeah, I think they enacted all these laws because years ago there was a lot of scams, years ago, now, probably still some now, but you know, I remember up in Lehigh Acres.
Oh, right.
So people were buying land and, you know, whatever.
Well, my favorite joke is the guy from Ohio that hires a surveyor to go out and survey some property out in basically the Everglades, and the surveyor calls him up and says, "Did you want that in liters or gallons?"
Oh my gosh, that's a sad story. So where do we go from here then if we can't settle?
Well, if we can't settle, as I said, and I just want to, get a little bit further on this. There are some ways of pushing people to encourage them to settle. There are things called offers of judgment or offers of settlement that sort of up the ante if people won't settle. If people file a totally frivolous lawsuit against you, you can do a motion for sanctions, which can mean that not only will the other party pay your attorney's fees, but the other attorney may have to pay part of your attorney's fees. But if all of that fails, then you just prepare for trial and you lay out the facts as carefully as possible, bring in all your witnesses, the judge makes a decision. And generally, most of the time, that is going to determine the outcome. Yes, there are appeals, but appeals are much more limited than I think people are led to believe by TV.
And what would be, before we wrap this show up here, what would be a timeline for some of these events, short and long?
Well,
I know that's a crystal ball, but I mean, from the outside, because every time you go to court, you have to get on the docket, and for arbitration, you said you try and do within 10 days or so, but
it can be very time consuming. I think a case like this may last a year to 2 years, and if there's an appeal, it will last longer than that. Now, in certain instances, you can get it expedited if one of the parties is over 65, for instance. There are a number of tools that litigation attorneys use to try and get to a quicker decision. For instance, a motion for summary judgment often can wrap things up within a few months. So I try to be very candid with clients that this is not only an expensive proposition, but it is emotionally exhausting.
Right.
Now, yes, most of these contracts provide that you'll get attorney's fees if you're the prevailing party. And the wonderful thing about Florida law is even where a contract says there's attorney's fees to only one side, Florida law says it automatically goes both ways. But I find sometimes the emotional toll on people, if they get too emotionally invested, is what makes them want to settle. Yeah. So it really depends on how cast iron your stomach is sometimes.
that's right, and how much money you got at stake. So, well, thank you for coming on the show, and I hope you come back again and give us another insight on another problem that could occur in a real estate transaction.
All right. Well, I enjoyed it very much. Thank you, Jim.
Thank you. Thank you.